I didn't argue when Karen started shouting across the table, waving her copy of the lien paperwork like it was a holy decree. Her voice cracked with that mixture of confidence and fear you only hear from someone who's about to realize they've made a huge mistake. I just placed my folder on the HOA's conference table, flipped it open, and slid out one piece of paper, the closing title, embossed with the county seal. The date clear as daylight. I watched her lawyer's hand pause mid-gesture when his eyes hit the document. The seal, the lot number, the chain of title, all there, notarized and filed years before this HOA ever existed. His lips parted, and for once Karen went quiet. It was one of those rare silences that felt physical, like the air itself had changed weight. "Where did you get this?" She finally asked, her tone lower now, more brittle than before. "From the county records," I said simply. "You might want to check the effective date before you file another lien against property you don't own jurisdiction over." No yelling, no drama, just the sound of her chair creaking as she sat back down. I'd spent too many nights reading old closing documents and title transfers to enjoy the moment too much. I wasn't there for revenge, not yet. I was there to prove ownership, to end months of false claims, harassment, and threats. And the best part was, I hadn't even shown them the rest of the folder yet, the survey maps, the HOA's original boundary filings, and the county assessor's memo confirming the HOA had no authority over my lot whatsoever. I'd waited 3 months for that meeting. 3 months of letters, fines, and public shaming attempts. And all it took to end it was a single page I'd already had in my possession since the day I moved in. Before all this nonsense started, I didn't even know what an HOA actually did. I'd heard jokes. Of course, stories about people getting fined for mailbox colors or for leaving their trash cans out too long. But I honestly thought that kind of thing only happened in the suburbs. In those brand new developments where every house looks like it was stamped out of a mold, my place was different. I bought the lot because it was at the edge of the subdivision, technically part of it on paper, but physically separated by a row of cottonwoods and a narrow creek bed. You could barely even see my house from the main road. That's what drew me to it in the first place. The quiet, when I closed on the property. It felt like the beginning of something steady, not glamorous, not dramatic, just right. I'd been working long hours in the city, saving every bit I could for something of my own. The house wasn't much at first, a single-story ranch built in the early 70s. The kind of place with sun-faded shutters and that particular smell of dry lumber that hits you when you walk in. But it was mine. I remember the first few weeks so clearly, how the mornings smelled like dew and pine, how I could hear the creek running faintly after a rainstorm. I spent those early days fixing small things, repainting the porch rail, repairing the sagging gate, mowing the patchy lawn. It was peaceful work, the kind that quiets your mind because it's just you. The tools and time, there was something deeply satisfying about that stillness. I'd sit on the porch in the evenings with a coffee, watching the light fade off the ridge behind my house. Sometimes the neighbors' kids would ride by on their bikes, waving. I'd wave back. That was about the extent of my social life out there. Simple, neighborly, and refreshingly uneventful. I wasn't looking to make a statement, join a committee, or improve the neighborhood aesthetic, as they like to say later on. I just wanted to take care of my own place, plant some shrubs along the fence, and maybe someday add a workshop out back for my woodworking projects. If you had told me then that this quiet little slice of land would turn into a battlefield, not with bulldozers or lawyers at first, but with notices, fines, and thinly veiled threats, I probably would have laughed. I didn't move here to fight. I moved here to breathe. It started, as these things usually do, with something so small and stupid I almost ignored it. A yellow notice taped crookily to my front gate one humid morning. It flapped in the breeze, half-soaked from overnight dew, stamped with the bold, self-important header, "Notice of Violation." At first, I thought it was a mistake. My lot sat apart from the rest, and the HOA rarely came down my way. But then I read the reason printed in block letters: unauthorized structure, non-compliant fencing, material visible from roadway. I remember actually laughing. The structure they were referring to was a short stretch of lattice fencing I'd put up beside the creek, to keep my dog from wandering too far. It was 10 feet long, untreated cedar, and set well within my property line. I'd checked the setback before installing it. The kicker? You couldn't even see it from the road unless you stopped your car and craned your neck through the trees. I called the number on the notice, expecting a quick clarification. That's when I first met Karen. She answered the phone like she'd been waiting her whole life for it. Sharp, rehearsed, efficient in the worst possible way. She introduced herself as the HOA president and immediately told me that all exterior modifications must be approved by the architectural committee. I explained calmly that I hadn't modified anything visible to the neighborhood, and more importantly, my lot sat outside their recorded improvement zone. That's when she asked for my lot number. I gave it to her. There was a pause. Then she said something I'll never forget, her tone dripping with that smug certainty people use when they think paperwork equals power. Well, if you're inside the subdivision map, we have jurisdiction. That's how it works. I tried to explain that my property was recorded separately during the original land transfer, an excluded parcel on the closing plat. But she interrupted before I could finish. If you don't remove the fence by Friday, she said, we'll begin fining you at the standard rate. Click. That was the end of the call. I remember staring at my phone afterward, confused more than angry. I walked out to the fence, looked around, and thought, there's no way this is real. But by that weekend, another notice appeared, this one with an actual fine amount. $250 per day until compliance. It would have been almost funny if it hadn't been so invasive. I was new there, and I didn't want trouble. So I wrote a polite email attaching my property survey and the recorded deed, pointing out that my lot wasn't governed by the HOA. I even offered to meet with them if they needed clarification. No reply. Then, a week later, another letter arrived, certified mail this time, stating that the known compliance was escalating to a formal violation, and that further refusal to comply may result in a lien. That word, lien, hit differently. I'd only just finished paying closing costs. I knew what that word meant, and it wasn't something to throw around lightly. Still, I thought it was all a misunderstanding. A paperwork glitch? A simple matter of showing the right documents to the right person? I didn't know yet that Karen wasn't mistaken. She was testing me. At first, I still believed reason could fix it. Maybe that's the part of me that always tries to see the bureaucratic side of things, the assumption that if you just show the right papers, calm and logical, people will do the right thing. I had no idea I was dealing with someone who thrived on confusion and intimidation. I started my diplomacy the following Monday. I drafted a detailed email to the HOA board attaching PDFs of my recorded title, the parcel map from the county assessor, and a copy of the legal description from my closing documents. I highlighted the clause that clearly excluded my lot from the HOA's covenant area. My tone was measured, almost apologetic, as if I needed to justify my own property rights. 2 days later, I got a one-line reply from the HOA's general address. Unsigned. Our records indicate you are subject to all HOA covenants and enforcement actions. Fines stand. That was it. No name, no reference to the attachments, nothing. So I printed out the entire email thread and walked down to their next open meeting. It was held in a borrowed church hall, the kind of place that still smelled faintly of coffee and folding chairs. There were maybe 12 people there, retirees. A couple of parents and Karen sitting dead center, arms crossed like she was running a congressional hearing. BLE, the kind of silence that comes from fear, not indifference. So I handed her a folder with copies of my title, my plat, and the assessor's notes. She didn't even open it. She slid it aside like it was junk mail. You can leave your materials, she said. But the board's decision stands. Non-compliance fees will continue until rectified. That was the moment something in me shifted. It wasn't anger, not yet. It was something colder. I realized I was no longer dealing with confusion. This was control. She knew exactly what she was doing, and she was daring me to fight back because she thought I couldn't. I stopped emailing after that. I didn't show up at their next meeting. When the next fine letter arrived, this one totaling nearly $3,000, I didn't even respond. I let the silence hang, knowing full well how people like her hate being ignored. Instead, I started reading. Every evening after work, I'd sit at the kitchen table with a pot of coffee and pull up county records, HOA filings, and case law. I learned the difference between a recorded plat and an annexed covenant. I read about improper filings, jurisdictional overreach, and even a few local lawsuits where overzealous HOAs got themselves dissolved by state courts. That's when I started building my own file, thick, methodical, meticulous. I wasn't planning a confrontation yet. I was preparing a correction, and when Karen finally pushed too far, filing that bogus lien against my lot with the county clerk, my response wasn't emotional. It was procedural. The lien notice came folded inside a thin envelope, certified with that familiar self-importance of a government document. When I saw the OS name listed as claimant, I knew exactly whose hand was behind it. Karen had made her move. She'd filed an encumbrance against my title, claiming unpaid community fines totaling $5,750. It was the perfect bluff. Most people faced with something official looking like that would panic, call their bank, pay something just to make it go away. But I wasn't most people anymore. By then, I'd been living in the trenches of county land law for 3 solid months. I knew exactly what she'd done, and more importantly, what she hadn't. Under state statute, an HOA can't file a lien without a valid assessment tied to a recorded covenant. And my lot? My lot had never been annexed into that covenant. I had the title, the legal description, and a copy of the HOA's own formation documents to prove it. The moment I saw that lien, I didn't get angry. I got quiet. The kind of quiet that comes when you realize you've got someone cornered, and they don't even know it yet, that night. I pulled out every document I'd collected and laid them across my dining table like puzzle pieces. My original title and closing statement? Check. The subdivision plat from 1983 showing the HOS jurisdiction stopping 1 parcel short of mine? Check. The developer's memo, the assessor's letter confirming exclusion, and even an archive zoning map showing the original boundary line, but the real nail in the coffin was buried in the county recorder's online system, a public record titled Declaration of Covenants, Conditions and Restrictions, CC&RS. It listed every parcel number under HOA control. Mine wasn't on it, so I printed it all. I mean everything. 98 pages total, tabbed, cross-referenced, and highlighted. I even built a timeline showing when the HOA was incorporated, when the covenants were recorded, and when my property was sold by the developer before the HOA ever existed. Every date lined up perfectly. My ownership predated their authority. They had no jurisdiction, none. Still, I knew facts alone wouldn't stop Karen. People like her survive on intimidation, not evidence. So I went one step further. I called the county recorder's office and asked about the process to challenge a fraudulent lien. The clerk on the phone, a woman named Donna, listened patiently, then said, "If it's not a valid claim under a binding covenant, it might constitute filing of a false instrument. You'll want to file a counter-affidavit." That phrase, false instrument, lodged in my head. I wrote it down. I could practically hear Karen choking on those words if they ever came up in a hearing. So I filed it. Calmly, precisely, with every supporting document attached. My counter-affidavit included copies of my title, plat map, and a notarized statement citing the HOA's lack of authority. It took about 2 hours at the courthouse and cost me $11 to dismantle 3 months of harassment. Then I waited. Weeks passed. The HOS letters stopped. The board went quiet. Even the little patrols they used to do, their compliance walks, didn't come down my road anymore. I figured maybe they'd realized their mistake, quietly withdrawn the lien, and moved on. But Karen wasn't built for retreat. She resurfaced 1 month later, calling an emergency board meeting to address what she called defiance of community governance. That's when I knew I'd be attending, not to argue, but to end it. So I packed my folder, the thick binder of documents. the counter-affidavit stamped by the county, and my original closing title. I remember the weight of it in my hand. It didn't feel like paperwork. It felt like truth with a spine. When that night came, I wasn't nervous. I wasn't even angry anymore. I was surgical. The emergency meeting was held on a Thursday evening at the same church hall where they'd dismissed me months earlier. This time, though, the parking lot was packed. Word had spread that Karen was going to take legal action against one of the homeowners for non-compliance. I smiled to myself when I heard that. She thought she was about to make an example of me. Inside, the room buzzed with quiet tension. People were whispering, shifting in their metal chairs, avoiding eye contact with me as I walked in. Karen sat at the front table, her binder open, her posture perfect, the HOA logo printed on a stack of envelopes beside her. It felt more like a courtroom than a community meeting. She started right in, gavel tapping the table. This meeting is called to order to address ongoing violations by Lot 72 regarding non-payment of fines and refusal to comply with HOA architectural standards. She said it like she was reading scripture. I waited. Karen went on to explain, for everyone's benefit, that the board had exhausted all diplomatic channels and had no choice but to enforce a lien to protect the community's interest. A few people nodded, others shifted uncomfortably. She loved this, the sound of her own authority echoing in a room. When she finally looked up and said, "The homeowner in question is present. Would you like to speak before we vote on further action?" I stood. "Sure," I said quietly. I didn't bring notes. I didn't need them. I just walked to the table and placed my thick folder in front of her, the same way someone might place a chess piece that ends the game. I said, "before you vote on anything, you might want to review the county records. Specifically the title history of Lot 72. Karen rolled her eyes. "We've reviewed your so-called evidence before. You're subject to the same rules as everyone else?" I nodded slightly. "Then you won't mind if we confirm that with the county's own documentation." I opened the folder, slid out the first page, the closing title, embossed seal glinting under the fluorescent light. "This is my recorded title from the day of sale, dated 5 years before your HOA was even incorporated. It clearly lists the property as not subject to any covenants, conditions, or restrictions." Her lawyer, sitting 2 chairs over, leaned forward. I caught his eyes scanning the page, then the next, the subdivision plat, the county assessor's exclusion memo, the covenant list missing my parcel number. His expression changed the way someone's does when they realize they've walked into a trap. "And this," I continued, pulling out the last document, "is the counter-affidavit I filed with the county recorder, officially nullifying your lien as a false instrument." I let that phrase hang in the air. "Filed under State Statute 14-10A, Section 3. Karen blinked. For the first time, she didn't speak. "You filed a lien," I said evenly, "on property you have no jurisdiction over." "Which means you just attempted to cloud title, a felony in some counties." "I don't plan to pursue charges, but if you don't withdraw the lien publicly and in writing by end of week, I'll have no choice." You could have heard a pin drop. Her lawyer started whispering rapidly, flipping through the documents. Karen's face had gone pale, not embarrassed, but rattled. She'd finally hit the edge of her bluff. I turned to the rest of the room. "For the record," I said, "I'm not here to pick a fight. I'm just asking that this HOA stop pretending to own land it doesn't. My deed predates your organization." "The county agrees. So either remove the lien or I'll let the state handle it." Then I gathered my papers, slid them back into the folder, and walked out. No yelling, no threats, no smugness, just quiet steps on a tile floor. Behind me, I heard the board whispering in a panic. Someone muttered something about checking the filings. The meeting ended early that night. 2 days later, the lien vanished from the county record system. I didn't expect an apology, and I didn't get one. What I did get, about a week later, was a very short letter from the HOS attorney, a different one this time, confirming that, upon further review, the lien against Lot 72 has been rescinded due to clerical oversight. Clerical oversight, that was their polite way of saying we got caught. I didn't frame the letter or post it online. I just folded it once, slid it into the back of my binder, and put the whole thing away in the top drawer of my desk. That drawer still sits half full of paper, titles, plats, statutes, old reminders of a war one didn't start but refused to lose after the lien was withdrawn. Everything changed in small, quiet ways. The next HOA newsletter arrived without Karen's name listed as president. She'd resigned for personal reasons. Word around the neighborhood was that the rest of the board had grown tired of her methods, especially after their lawyer confirmed they'd almost been sued for filing a false claim. The meetings went silent for a while. No more notices. No more fines. Even the patrols stopped walking the back lots. For the first time in months, I could drink coffee on my porch without wondering what fresh nonsense would show up in my mailbox. Neighbors started waving again. Not all of them, but enough. A few stopped by to quietly admit they'd been fined for similar violations, things just petty enough to not fight over. One older couple told me they'd been charged $400 for painting their shed the wrong shade of brown. I showed them how to pull the HOS filings at the county website. By the end of that summer, 3 separate homeowners had challenged their fines, and one, the power Karen once carried in her clipboard and gavel, had evaporated. She still lived somewhere up the road, but I rarely saw her. Once, months later, I caught a glimpse of her at the post office. She saw me too. We didn't speak. She just turned away, pretending to study a rack of envelopes. I didn't feel vindictive. I didn't even feel angry anymore. What I felt was a kind of deep, practical peace, the kind that comes when you've been through something absurd and come out knowing the law works when you know how to use it. Now, my days are quiet again. I still fix the fence, still sit on the porch with coffee, still hear the creak when it rains. The difference is, I know the boundaries, not just mine. But sometimes people ask if I ever thought about moving after all that. I tell them no. Because peace isn't a place, it's a boundary you defend calmly, completely, and without apology. These days, when I drive through the subdivision, a few of the board members, new ones now, still wave. Some don't. Either way, it's quiet again, and that's all I ever wanted.